It's great to be here with you today, and yes, we're going to talk about various elephants in the room, but really want to focus on data security and to go over some basic principles and review some of the design of this project, as well as to give consideration and hopefully enter into some dialogue with you about some options that are currently under consideration at the department regarding data sharing. So this is an overview of what we're going to discuss today, and you can take a moment to look at that. And as we get further in towards the end of the presentation, as I say, hopefully we're at a critical juncture where certain decisions need to be made about the possibility of data sharing and what that might look like. And I thought this would be an outstanding opportunity today for you to provide us with some feedback that we can take back to the department and further those discussions. As you can see from this slide, historically, federal student aid does not disclose information about those making application for Title IV student aid. We hold our responsibility in terms of personally identifiable information and just keeping very private who those individual students are that are applying for Title IV aid. It's really nobody else's business. However, the statute in Section 483 allows for the following. The Secretary shall ensure that data collection under this paragraph complies with the Privacy Act, and that any entity using the Fafsa developed by the Secretary shall maintain reasonable and appropriate administrative, technical, and physical safeguards to ensure the integrity and confidentiality of the information, and to protect against security threats or unauthorized uses or disclosures of the information provided. Data collected on the Fafsa shall be used only for the application, award, and administration of federal aid, state aid, and aid as provided by eligible institutions. So that's the context that we're dealing with, or in which we're dealing. So privacy is very, very important to us, and you can see how our historical approach, our culture about protecting that information, as we get to the latter part of this presentation, impacts what we see as a possibility and what limits certain possibilities as well. This is just a quick model. Now, hopefully many of you had the opportunity yesterday to attend one of the sessions, an outstanding session given by one of our contractors that talks about the student aid information gateway. The gateway provides access to a whole host of our partners to gain access to a variety of databases and systems that we have. At the beginning, if you think about the life cycle of financial aid, the beginning you would have to think about the Fafsa at the CPS, or Central Processing System, where on an annual basis we process somewhere between 20 and 25 million applications. And in fact, as you can see from this slide, under this project, the Fafsa completion project, your primary destination point administrator will be that individual that will go to the SAIG and initially provide us information. You'll see on the bottom here, it talks or it references non-primary DPAs. That's an application used, this describes a process used by others for other purposes. It's more limited, of course, in the Fafsa completion project in that only a primary DPA will be that individual who will be providing and then downloading information from us. Another part of that process, of course, is the enrollment process, which you will all be going through in the very near future. As you can see from the bullets here, there are a variety of DPA responsibilities, again, destination point administrator responsibilities, and as well as responsibilities for the president, CEO, or in most of your cases, it will be the superintendent. And I want to touch on a number of these in the next couple slides, but before we leave this slide, I want to strongly suggest, and this is a takeaway that you might want to write down, I really want to strongly urge you to encourage your administration to print out that document and read it very thoroughly. There are two parties that will be signing. It will be your superintendent or whoever the chief executive officer is within your administrative organization, as well as the primary DPA. Because that is such a really a very slick electronic application process, it's very easy. And if you think about your own behavior, anytime you pull up a new software product, how many people actually read all that stuff before they say, I accept? Well, this is the caution that I'm offering for at least those two individuals that are going to be signing on the line. They want to read very thoroughly what it is they're signing. And that's just, that's so you have a fair appreciation of what your responsibilities are and what you're agreeing to do, which I'll go over in some detail. But as you can see under the primary DPA, the last point there is penalties. There are penalties if involved, and again, it's not a threatening kind of thing, it's a cautionary thing. You want to make sure that your processes are thorough and secure, as we read earlier, to maintain the requirements of the statute. Because should someone go off in another direction and fraudulently use some of this information, of course, that could mean conviction of a misdemeanor and monetary fines. So it can be very serious. I also want to point out in the last bullet of this slide, the two responsibilities for the chief operating officer of the entity, the LEA. And that is, they are certifying that primary DPA, yeah, this is my person, as well as taking on the responsibility as if there is a change, that primary DPA is no longer there, it is the CEO, superintendent, who has responsibility to submit that change to us immediately. That can't be passed on, referred to someone else. That is the responsibility of that superintendent. So again, emphasize that they want to print this out and review it. I do want to talk about a couple of those other bullets. The first one here is in terms of an established relationship. Each LEA must be able to document that there's an established relationship between the DPA's employer and the student. So for example, the easiest one that comes to mind, of course, is that an LEA would have attendance records for all the student data that they're submitting. They can show a direct relationship that the list of students that they're submitting to the Department of Education are their students. And to give you an opposite example, that also means then you cannot submit information about students that are not within your jurisdiction. Consent to monitoring. This is another one of those things that the primary DPA needs to be aware of, because when you sign our agreement, by applying for access, you are agreeing to, you're consenting to monitoring, recording, auditing, and acknowledging that information gained in this manner may be disclosed by us to other third parties, which are generally going to be law enforcement agencies. So we don't go in, obviously, to all the details of what that monitoring, auditing will be, but it's just to let those individuals who have this responsibility know that there are ongoing and a variety of activities that change. And I can think in some other applications there have been very serious changes in this past year to look at people who are trying to gain access to our systems. So that's a process that evolves constantly, and we use that to, again, protect the security of the data. So we want DPAs and LEAs to ensure that the Fafsa data is protected from disclosure to unauthorized personnel. Now you'll notice here, authorized personnel, again, I was talking about the more generic, and as I've said previously, for this project, authorized personnel are going to be defined as the primary DPA. The latter portion here, there are provisions within the agreement regarding data breaches and those responsibilities. I think a lot of times when that happens, particularly if it's a newer individual, they might be reticent about contacting us and saying, whoops, we've had a problem. That's the absolutely wrong thing to do. We are your partners. We understand that we don't know the particulars, but unless we know about it, we can't help you with it. So it's imperative that should a problem arise, that the first thing you do is make this contact so that we can begin working with you. So it becomes very, very important. Okay, another one of those, another element to the enrollment agreement process is in terms of following the FERPA rules, so we want to talk a little bit about that today. This is just a reminder of the definition of directory information. It's information contained in any educational record of a student that should not generally be considered harmful if shared, or would not generally be considered an invasion of privacy. And the distinction is that there is a process that we'll talk about very briefly that on an annual basis an institution has a requirement to define what its directory information is. And this is generally, FERPA is generally applicable because you were talking about dependent students, so it's generally regarding the rights of the parent to access the educational record and to ask for a review of that. And in this regard, it's the institution's responsibility to declare to the parent, or in this case, an eligible student, one who's reached 18 years of age or who is attending an institution of post-secondary education. They sort of have an equivalence. You have a parent or an eligible student. So these declarations would be applicable to both those entities or parties. And this is just a reminder about the annual notification. It is consent to disclosure of personally identifiable information contained in the student's record. So this is an annual process, and one of the things that we've done to move forward in the project is Dina had provided, I think it was August 27th, a model. It wasn't something that you had to do, it was just a reminder of here's a good practice. About including in your institution's annual notification to parents and eligible students of the directory information associated with this particular project and how that directory information is going to be used. Now, part of the elements of the annual notification is parents and eligible students have to be notified of their rights, and in this regard, you're explaining that the Fafsa completion data is sent from LEAs to us. It's considered directory information, and it's consistent with this project's purposes. And that all ties into the law, and it's said in that manner so that it is applicable with this law. And as you may recall or know, the information, the PII involved in this process is going to be that when the DPA sends us listings that provide the first name, the last name, the zip code, and the date of birth of your seniors. Now, this is probably one of the most important screens in here, and that is an educational agency may not disclose directory information in certain cases. And that is when you provide your annual notification to parents and eligible students. And when you look at that particular part of the regulations, they give you broad authority to do that in whatever is the most effective method that you can find. So you're not required necessarily to do it in writing. You're not required necessarily to do it on the web. They just tell you to do it in the most effective means that you can identify, which is very broad. Rules aren't generally written that way. But you have to provide parents and eligible students the opportunity to opt out, and that is to refuse. When you say, okay, you've identified these 4 points of personally identifiable information and how it's going to be used with this particular project, now you also have to specify the time frame that either party, the parent or the eligible student, have to contact the school and say, nope, I'm opting out. I don't want you sending that information about me for this project. So the next takeaway is that you may want to write down, what edits do we have in place or will we have in place to identify those opt-outs? Because that information cannot be sent to federal student aid. Those are the ones, so you need something in place that will ensure that that does not happen. Otherwise, you'll have a FERPA violation. So here's just a little reminder of the completion project design. The LEAs are going to send, again, the 4 pieces of personally identifiable information for all your seniors except those who qualify as opt-outs. We will query our system, and as I say, we're processing on an annual basis now between 20 and 25 million applicants per year, and we will provide some or all of the following information: a completion flag, which we'll talk more about, the date the FAFSA was submitted, and the date the FAFSA was processed. Now, these completion flags are important, so we'll go over them now, and we may come back to them when we get into a later part of the discussion with the feedback session. But there are 4 flags there. The first one, we don't have a record of this individual in the CPS, in the Central Processing System. If we return a flag, a completion flag of 1, that means we have something on file, but it's incomplete and it lacks signature. Now, such a record, should we return a flag of 1, will maintain that status until such time as we receive the signatures, or 15 days, whichever is shorter. After 15 days, a completion flag in our system converts to a flag of 3. Now, the one we all want to get, of course, is a completion flag of 2. That means the FAFSA has been submitted and it is complete. An EFC, or expected family contribution, which is what post-secondary institutions use to determine a student's need, and then once they have that, they can go about the process of awarding Title IV aid. A code of 2 is the goal here. The student has done everything they need to do. The calculations have been completed. Both the institutions that the student has indicated on the FAFSA, as well as the student, are contacted, and they are provided this data, so they know what their EFC is as well. Now, not too many students know what that means, of course, which is an area for both the financial aid office on their campuses, as well as the counselors that either you are or you work with. That should have and does have much meeting. And then the FAFSA, the last flag, there are 3. Again, we have a FAFSA, but it's incomplete. There's some other problems, and those can be a whole myriad of problems. Part of what we do for our institutions is we have a series of codes, and each year we have a manual that they can download from our IFAP, Information for Financial Aid Professionals website. It's available to the public. And then they can read those codes and see the comments that we're making. And those comments are telling the financial aid professional, here's what's wrong and what you need to do to fix it. And they're giving the student some information. It might be a specific thing. You need to submit a certain form to your financial aid office, to something more generic. You need to sign it. You need to contact your financial aid office. So at this point, excuse me, in the presentation, what I'd really like to do is share with you some ideas that we have been discussing at the department. This next section is an opportunity to do some sharing about issues currently under consideration. I want to reiterate, no policy decision has been made, but it will be made soon. We've been, in fact, while I've been here and last week before I left, we've met with a series of attorneys within the department to discuss these issues, and I'm sure right after I get back, we'll continue those discussions. But part of what we know at this juncture is that many of you are working with a variety of other entities, and in some cases you would like to share some of this information with them, some of your partners. When you, just to reiterate, when you sign the the SEIG enrollment form, that's an agreement between the department and the LEA. And that's as far as our data can go currently. But because we know you have these other partners, we're exploring, again, within our historical context, and because we have data security people, privacy attorneys, our Office of General Counsel, and again, just the general culture at Federal Student Aid, we do a lot and everything that we can come up with to protect information. So broadening, looking at, giving some consideration to third-party redisclosure from an LEA to another entity is a stretch for us. It might, and I want you to understand why. I think that's important. So currently we're in the process of developing these ideas. And part of what we're looking at is a written agreement that would allow the LEA, as the data provider, to share certain information with the data recipient. Again, when we talk about the various portions of the department that have been involved in this discussion, our data security analysts, our privacy attorneys, other members of the Office of General Counsel, and Federal Student Aid, we're looking at what information can we release, how can we do that in an effective manner, and yet how can we build around that the lowest possible risk model. And what we've been discussing so far, again, what I would like to have some reaction to, is the kind of model where we would first look at currently approved grantees. As you can see in the third bullet there, the data recipient would be someone like Trio, Upward Bound, Gear Up, Talent Search. These are entities that have already been applied to us, they've been vetted, they've been approved. And the reason, in part, why we feel there's less risk there is they have, they've been in a relationship with us. Sure, if we found out that we went down this path, if this is approved, and any entity that is already currently approved sort of diverge from our agreement, we could hit the switch and say, okay, LEA, you can no longer share any, you can no longer redisclose information with them. But these people have a larger vested interest because of the other programs that they're involved with us, as opposed to another entity, maybe a community-based organization that we have no relationship with. There's where our attorneys and our security folk aren't ready yet to move the experiment to a broader cadre of people. What we're also talking about or have under consideration are written agreements as approved by the Secretary that would be used then between the LEA and a grantee. And this, again, provides for all what we think are the requisite elements, terms of the agreement, so that we can be best assured and assure the individuals whose data is being shared that we've taken all the applicable steps to mitigate any risk. So towards that design, we are currently in the process of matching each of the LEAs with the currently approved grantees. And what we envision doing is producing a list, and then should this decision, if this decision is finalized in this manner, we would be able very quickly then to be able to provide to each LEA, here is a list of your current grantees. So you could tell us whether or not you want to move forward in this fashion, whether you would want to be able to do redisclosure with these other folk. So the agreement, again, the data recipient, the grantee, would have to have an established relationship with any of the students that they're working with. And as you can see in this example here, let's say the LEA has submitted to us the records for 1,000 students that they're working with, 1,000 seniors. What we would envision then is when a grantee wants information, some of the Fafsa completion data from the LEA would not simply share all 1,000 records, because that's going to be beyond the scope of the individuals where they have an established relationship. So one design that we have under consideration is parallel to the system between the LEAs and the department. So you would envision a grantee providing the 4 data elements, the privacy information about the students that they're working with, last name, first name, last name, date of birth, and zip code, and then the LEA could do a similar matching and provide some limited information. And I say limited information because, again, FERPA plays here. And what we're talking about is a model where the LEA could return a flag of, potentially a flag of 1, 2, or 3. They would not be able to return a flag of 0. And the reason for that is within the FERPA regulations in, if you need to know, it's 34 CFR 99.31A4. I'm sure you got that right. But when your campus attorney asks, you know, so what reg did this guy cite? You'll have it. Meet me later and I'll write that down for you. But what this provides for is an exception, a very important series of limited exceptions. You'll recall that generally under FERPA, before you can disclose any information about an individual and their educational record, you have to have written consent, except where these exceptions apply. And the exception under A4 allows for disclosure in connection with financial aid for which the student has applied if the information is necessary for such purposes as to determine eligibility, determine amount of aid, determine the conditions for aid, or determine the terms and conditions of the aid. And what we're looking at in terms of legally is whether or not we can, our initial conversations up to this point have been the flags 1, 2, and 3 are definitely only applicable to students who have submitted an application. Now the question is, can we apply the exception to all 3 of those? We can make a pretty simple case, or it's easy to make the case it's applicable in 1 and 3. It's a little bit more difficult to make the case for 2. Although I think there's enough room in there, the reg is written broadly enough that we can successfully make that case. But as you see in the bottom bullet here, what you cannot do, you wouldn't be able under this design or potential design to return a flag of 0. Why? The exception doesn't apply. So unless you built a whole different system, and that could be done, and we've discussed some of those options as well, up to this point we've rejected them because it isn't direct. I think the department, well, not I think, I know the department would rather stand solidly on these regulations and move forward and offer you an option that is built upon these regulatory requirements rather than some more indirect ideas that we've had under consideration. So what I'd like to do at this point is I'm going to have a seat and get my notepad out. We have a couple microphones up here, and I'd like some just initial reaction to this proposal that we have under consideration.
First of all, I'm telling you to please, please, I'm begging you to definitely go forward with those proposals that you're laying out. I happen to be fortunate enough to work in a district where we have a number of community partners that really want to support us in this work. And it's very difficult to tell them, we're sorry, we can't share this information with you. Which leads me to a question about that. If the student or family signs a release to say that they want to share this information with the community organization that they're working with, can we then provide that information?
There are some models that would provide for that, and that's something that we have further under consideration. So when we respond, if there are those options as well, we would describe those in much detail.
And then I have a follow-up question regarding that with sharing the information with classroom teachers. So, for example, if we have the AVID program in our schools and the AVID teachers want to support this work, are we able to share this information with those teachers?
That I'll take back because I really need some further guidance from counsel on that. I just don't happen to have that answer with me today. It's not one that I've had an opportunity to discuss with them.
Just a clarification, I mean, in our district, we obviously maintain, and in our student information system, an opt-out flag, which denotes if the student opted out of having the directory information release. Now, we operate under various exceptions in the FERPA law. For example, reporting data to the state for funding, that opt-out does not apply. Reporting data to organizations that we have a contract with to provide services such as gradebook or others as part of educational interest doesn't apply.
That'd be an A1 exception, yes.
Right. For this specific project, I just want to clarify, if a student has opted out of the directory information being released, are we allowed to submit that data to the Fafsa completion project to determine Fafsa 0, 1, 2, or 3 status?
The question is, if a student, if the applicable party, either the parent of a dependent student or an eligible student, opts out, can the student's privacy information be sent to the FAFSA completion project? And the answer is no, it cannot. That would be a FERPA violation. So that, again, that's why I emphasize that's a critical takeaway, that you need to have discussions within your LEA and with your DPA, primary DPA. You want to know how the edits in your system, how that works to screen those folks, because you have to ensure that an opt-out record is not submitted. Yes, sir.
I think earlier you gave an example of some entity under this consideration that had been approved, maybe given us the names of like 225 out of the 1,000 kids, and we can only return the flags 1, 2, or 3. But if they only get 200 kids back out of that 225, aren't they going to automatically know that those 25 are a 0?
That would be the presumption.
So we just can't tell them it's a 0, but...
That's absolutely correct. You may not. And we'll leave them, they can presume what they presume.
Hi, so we are eager to share information with our many community-based organizations that support our students as well. I'm a little bit concerned about the cumbersome nature of that sharing. If, from what I understand, we would have to cull through the names of our students and determine which community-based organization works with which student and only share that information with them.
Essentially, that's correct. As in my example, if you have 1,000, if we've sent or received 1,000 records from the LEA and sent those back with the appropriate information from our system, you cannot, or the LEA cannot, share all that information with an entity that only has interaction with a subset of the 1,000. So now, I will say that while what we've had in discussion is a parallel model, and that's the one where the grantee would supply the LEA with the 4 data elements, and then you'd look at them and send them back the appropriate FAFSA completion flag, a 1, 2, or 3. That's one model. I'm sure there are many others. I'm sure that we'll have inquiries about that. And again, part of the reason we wanted to have today's dialogue, if some of you are already thinking ahead about another model, I'd like to know about that. We'd like to know about that.
So I guess I just want to state that if that is the model that we're talking about, I don't think that we could operationalize that in a way that it would be helpful for us.
Okay.
To have to spend the time to actually do that, unless I'm envisioning this incorrectly. If there was a way that the LEA, or the TRIO program, for example, could directly get that information because they do have parent releases signed on their students, if they could somehow get that directly, we'd be interested in that. I'm really concerned about the word getting out that we can share this with our TRIO programs and then us not doing that because from a staffing standpoint, we can't manage that, you know, that data transfer and that sharing. So, you know, in an effort to be a good partner, I would hate to have to say, well, we could, we're allowed to, but we can't because we can't manage it, because that's a public relations and whatever nightmare that I don't really want to have.
Right, and I appreciate that. And what this points out are there are a wide variety of needs out there, and what we're trying to do is, certainly we're cognizant of that, and we're trying to push beyond our normal levels of just saying, no, you can't share any data, and take a step in the right direction. We don't want to take too big a step in this phase of it at this early juncture. So again, what we're trying to do is mitigate risk and work with partners where we have an established relationship and not just throw the door open, because clearly that's not going to meet our needs, and we don't think it would comply with the law, quite frankly. But I understand the difficult position that could put you in. So I don't have another reaction, but I would encourage you, if you have those concerns, the last slide I'm going to throw up here has my email address on it. And I think sharing those kinds of concerns would be very helpful so that we have a broad base of reaction to discuss within our own work group. Or if you, in terms of your other suggestion, I think the another important element of that suggestion was, is the department planning on a different model where they could share the information directly with a grantee, because we don't have the administrative resources or capabilities to do the things that would be necessary. And we may not for the first phase, but that might be a second phase option. And I should say, too, that because of these conversations, I would characterize this as a short-term solution. This whole work group is also looking at some long-range options as well. So it's not limited to just this element or this phase. And those are going to be working on parallel tracks, but quite honestly, because they have broader impact, it's going to take us more time, and we wanted to give you something now, and we thought this was possible. The other potential solutions are just bigger, going to take longer time to work. Yes?
So I just have a clarifying question, and this came up with my group yesterday in that when they were talking about filling out the Fafsa form itself for undocumented students, they were saying put in a 000 for the Social Security number if they don't have a Social Security number. And then today you're saying that perhaps this information, and maybe it's just clarifying for me, could be shared with a police entity. And so I'm just sort of wondering, why would we encourage those non-documented kids to do that if this information could be shared in that way?
I really need to separate this out into two completely different parts of the process.
Okay.
The first part is, how do you get a FAFSA submitted for a student who either the student is undocumented or their parents are, if it's a dependent student. And that's where all the zeros come in. You'll notice when you look, and then that's separate and apart from FAFSA completion. FAFSA completion, we're not exchanging any Social Security number information, so an undocumented student that's supplied all zeros for either themselves or their parents, that's never going to be seen by the LEA, and it's just not a part of that.
No, but
project.
once the department has that information, and that, I mean, just even the name and the date and their birthday, can that information then be shared on the other side with those entities? I guess I'm just concerned for the kids.
Yeah, and my answer is that we've been collecting that information for as long as we've had the paper FAFSA, and no, we don't share that information with INS, DHS, USCIS. There is an exception to that, though, and the exception is that under certain very critical national emergency, they have access to all our information anytime they want it. 9/11 is an example.
Yeah.
So, and as a nation, we just need to recognize that. We'll probably want that to move forward. But for as many years as we've been collecting FAFSA information, that's not something, we don't have a data exchange with DHS, CIS for that purpose.
Okay, thank you.
So those folks are not harmed by us collecting that information, but it's vital that they know what the steps are so their FAFSA can be entered in and we can do the calculations necessary.
Okay, thank you.
Sure, good question. That's a big question. Yes?
Couple clarifying questions.
Sure.
I want to follow up on Manny's about the FAFSA opt-out. We do that also, and we give students and parents general categories of ways we'll share the data. We didn't specifically say we're going to do this FAFSA project in detail and have them give a choice of opting out of that. Our lawyer thought what we were doing was fine, but your presentation kind of indicates what we have to do here is what we do with special research projects is tell parents about this specific project and have them opt out of this specific project. Is that your interpretation?
You know, I would strongly suggest that you send me that question via email because we should probably go back and revisit the specifics and provide you with a specific answer to that.
Okay.
I could give you my opinion, but you know, that and $2 will buy you coffee at someplace other than Starbucks.
Okay.
But
two other clarifications. One is established relationships. We have a student leave in April, and May we upload data. We have to exclude the students who are no longer active? Or do we have a relationship because we had a relationship?
No, if you have or had. So let's say you had a student graduate in December, but you're doing some runs after that time. You've had a relationship with them, so they would still qualify. That wouldn't be a problem.
And your answer to the question about AVID. AVID teachers, at least the teachers, are employees of the LEA. So we can share data with whoever we want within the LEA as long as they're trained on the properly trained.
Right. With regard to the Privacy Act and FERPA, yes. But again, that's my answer. That would be, I would feel better about having a brief discussion internally on it.
Okay, thank you.
Sure. Other questions or comments? Does this seem like we're going down the right path? Is it too restrictive? Do you understand our risk concerns? Does that make sense to you? I mean, as taxpayers, I hope you know, you can appreciate that. So I appreciate your feedback. That will be very useful to us. One or two other things. Number one, next steps. One of the things I mentioned earlier, as we go down the road of this proposal, would be a written agreement. Rather than having 50 or 60 different types of written agreements, and you can well imagine that would be problematic for us, we will provide a model agreement for you. It would be probably something along the line of a FAFSA filing status information sharing and joint confidentiality agreement. We already have one that's near finalization. This has been in the works for some time. It's a work group of policy folks, programmatic folks, and our legal folks. So in fact, we spoke of that as recently as yesterday. Our legal team thinks that they can now shrink that down to something less than the size that it currently is, and that would be good for everyone. As I mentioned earlier, of course, you're going to be seeing the electronic version of the SAIG enrollment forms. Dina, will that happen in November probably? Yeah, I think November is our target date for that, so you can be looking for those. Model directory information notice. We may take another look at that. Again, if we apply the exceptions here, one of the advantages to that is it would not cause, there would not be a need for a change, although just because of this discussion, we may want to give consideration to, here are some new ideas that you could adopt. And it gets back to the question that was asked over on this side about if you have another project in that like a research project that wasn't previously disclosed in your annual notification, how do you deal with that? Do you amend it and provide the information? So we'll be looking at it, and we may provide additional information. And then here's my contact information. I always tell people, since I present on a variety of topics regarding student eligibility and institutional eligibility, around the country, I have a never-ending supply of emails, so if you do write to me, I ask for your patience. But I also want to conclude by saying I really want to thank you for what you do. As a practitioner for almost 37 years now, I'm reminded of what we do together. Generally, we help students and their families attain their educational dreams and potential one student at a time. However, remember that the change you offer has a generational impact. The student helped today has a friend, is or will be a parent, is an aunt or uncle, and they're going to help the next generation. So your work this year will have a lasting effect for generations to come, and for that, I applaud you, and I share your passion. Thank you.